Hello Year 12s and welcome to this video on the Victorian Civil and Administrative Tribunal, or VCAT. One purpose of this video is to recap on some information that you already know about VCAT. That is, the dispute resolution methods that it uses and the grounds on which and courts to which VCAT decisions may be appealed. Another purpose of this video is to give you some information about the structure and jurisdiction of VCAT. Together, this information will help you to be able to describe the purposes of a VCAT in resolving civil disputes and to discuss the appropriateness of VCAT in resolving civil disputes. You will learn more about the purposes of a VCAT and its appropriateness in resolving civil disputes in the next video. While you're watching this video, please take the very best Cornell notes that you can. These notes should focus on new information rather than information that you already know. As you are watching this video, make sure that you use the pause and rewind functions. Use the pause function if you need to stop this video to take notes. Use the rewind function if you need to go over any information contained in this video. You'll also need to have your vocabulary sheets open in front of you so that you can write into your vocabulary sheets the definitions of key terms or of other words the meaning of which you're unfamiliar with. On this slide, I've set out a definition of the Victorian Civil and Administrative Tribunal. Look down the left-hand side of your vocabulary sheets, find the term Victorian Civil and Administrative Tribunal and write this definition in there. The Victorian Civil and Administrative Tribunal, or VCAT, is a tribunal established under the Victorian Civil and Administrative Tribunal Act of 1998, Victoria, that consists of a number of specialist divisions which have jurisdiction to resolve different types of civil disputes in Victoria. Importantly, VCAT can only deal with disputes in Victoria, and it can only deal with a dispute where a statute gives VCAT the jurisdiction, that is the power, to deal with that type of dispute. There are around 140 Victorian Acts that give VCAT the power to deal with a whole range of different types of disputes. As a result, VCAT has a very broad jurisdiction. However, its jurisdiction is not as broad as the jurisdiction of the courts. For example, VCAT has no power to deal with general negligence or defamation cases, or with disputes between employers and employees, or with disputes between neighbours, or with disputes between tenants, or with disputes between car drivers. This is because the acts which give VCAT its jurisdiction do not include a power to deal with these kinds of disputes. Where parties have any of these kinds of disputes, they will typically need to go to a court, or perhaps to another dispute resolution body such as the Fair Work Commission, to have this dispute resolved. In addition, VCAT cannot hear class actions. Class actions can only be heard by the Trial Division of the Supreme Court. Later on, we will look in more detail at the kinds of disputes that VCAT does deal with. The other point to note is that VCAT only deals with civil cases. It does not deal with criminal cases. In fact, VCAT finalises more than 60,000 civil cases per year. That is, through mediation, conciliation or final hearings. This is more than the entire number of civil cases that the Victorian court system hears in a year. This slide sets out the structure of VCAT in terms of its staffing. The President of VCAT is required to be a judge of the Supreme Court of Victoria. The current President of VCAT is Justice Ted Woodward. There are also 8 VCAT Vice Presidents who are judges of the County Court of Victoria. The President and Vice Presidents are obviously legal experts, and they will typically rule on legal questions that come before VCAT. Because VCAT deals with a range of different disputes, it is divided up into 5 divisions that deal with different kinds of disputes. Each division is headed up by a deputy president. The divisions are further broken up into lists. Each list specialises in particular types of disputes, and each list is headed up by a senior member. Within each division and list, there are a number of senior and ordinary members. In fact, there are nearly 200 senior and ordinary VCAT members in total. Apart from the VCAT president and vice presidents, who are judges, the other members of VCAT, that is, the deputy presidents, the senior members and the ordinary members, have a range of skills and qualifications. Some VCAT members are lawyers, but others are planners, architects, medical practitioners, land valuers, and real estate agents. This is important because it means that disputes are dealt with by VCAT members who have the skills and qualifications that are most relevant to those disputes. For example, if there's a dispute between a builder and a client about the design of a building, then that dispute could be heard by a VCAT member who is an architect. This slide and the next 5 slides describe the structure of VCAT in terms of its divisions and lists. As I've said, there are 5 divisions of VCAT: the Civil Division, the Residential Tenancies Division, the Administrative Division, the Human Rights Division, and the Planning and Environment Division. And each of these divisions is further divided into lists which specialise in the different kinds of disputes that the division deals with. For example, the Administrative Division, which deals with appeals from decisions of regulatory bodies, is divided into 2 lists. One list, the Legal Practice List, deals with disputes between lawyers and their clients, while the other list, the Review and Regulation List, deals with decisions by government and other bodies in relation to the issue of licences, such as taxi licences and teacher registrations. On this slide, I've described some of the types of matters that the Civil Division deals with. These include disputes over consumer matters, for example, as where a supplier sells a consumer defective goods or services, disputes over commercial matters, for example, a dispute between a franchisor and a franchisee over the amounts owed by the franchisee to the franchisor. Disputes about domestic building works, for example, as where a builder does a shoddy kitchen renovation. Disputes over owners' corporation matters, for example, as where a person lives in a flat and they have a dispute with the owners' corporation, which is the body responsible for looking after the common areas, about the amount of car parking that's available. And retail tenancy disputes, for example, disputes between a shopping centre and the tenant of a shop in the shopping centre. On this slide, I've described some of the types of matters that the Residential Tenancies Division deals with. Essentially, these are disputes between landlords and tenants where the tenant is renting a place to live. This could be a house, a flat, a room in a rooming house, a flat or a house that is owned by the government, that is for public housing, or a caravan in a caravan park. The dispute might be over something such as the state of repair of the premises or a rent increase. On this slide, I've described some of the types of matters that the Administrative Division deals with. As I've said, this division deals with disputes between clients and lawyers and decisions by government and other bodies in relation to the issue of licences. For example, a travel agent might request VCAT to review a government decision to refuse to issue the travel agent with a licence that enables the travel agent to operate as a travel agent. In addition, this division deals with restricted dog breed decisions, as where a local council impounds or wants to put down a dog that it considers to be dangerous. Finally, the Administrative Division deals with appeals from disciplinary decisions. For instance, as where a medical board decides to ban a doctor or a nurse from practicing, perhaps because of some kind of misconduct. On this slide, I've described some of the matters that the Human Rights Division deals with. These include reviewing decisions that are made on behalf of disabled or mentally ill people who can't make decisions for themselves. Complaints about discrimination, for instance, as where an employer refuses to promote an employee because of their sexual orientation. Complaints about racial or religious vilification, and reviewing decisions made by doctors to certify or not to certify that a terminally ill person is eligible for voluntary euthanasia. Finally, on this slide, I've described some of the matters that the Planning and Environment Division deals with. These include reviewing decisions by local councils about the value of a property. This is important because the rates that a local council charges a property owner are higher the higher is the value of their property. The Planning and Environment Division also deals with complaints about the amount of money that the government pays to people where it compulsorily acquires their land, for instance, to build a new road. In addition, the Planning and Environment Division deals with complaints about a local council issuing or refusing to issue a planning or development permit for developments such as blocks of flats or multi-storey buildings. And the Planning and Environment Division deals with complaints about a local council approving or refusing to approve a subdivision of land. That is, the division of a large block of land into smaller blocks, typically for the purpose of constructing a number of houses that will then be sold off separately. We now come to the different types of dispute resolution methods that VCAT uses to resolve civil disputes. VCAT uses 3 dispute resolution methods. The first dispute resolution method that VCAT uses to resolve civil disputes is mediation. A VCAT member might refer a dispute to mediation before holding a final hearing, that is, a hearing in which the VCAT member makes a binding decision that resolves the dispute for the parties. The purpose of this is to give the parties an opportunity to agree a resolution to their dispute before VCAT decides that resolution for them. In the case of a mediation, a VCAT member will typically act as the mediator. As you know, the function of a mediator is to give each party a reasonable opportunity to explain their side of the dispute. The mediator cannot make suggestions to the parties about how to resolve their dispute, and the mediator cannot decide the dispute for the parties. Instead, it's up to the parties to see whether they can agree a resolution to their dispute. So, for a mediation to be successful, the parties must be willing to compromise with each other. In particular, where the dispute is about goods or services and where the amount in dispute is between $500 and $10,000, then VCAT might invite the parties to attempt to resolve their dispute by mediation using the fast-track mediation and hearing program. Under this program, the mediation is conducted by a mediator from the Dispute Settlement Centre of Victoria. However, if the parties are unable to resolve their dispute at the mediation, then VCAT will decide the dispute for the parties at a final hearing that is held on a later day. Look down the left-hand side of your vocabulary sheets, find the term fast-track mediation and hearing, and write a description of that term in there. The second dispute resolution method that VCAT uses to resolve civil disputes is conciliation. VCAT does this when it requires the parties to attend a compulsory conference before a VCAT member. The VCAT member acts as a conciliator by helping the parties with suggestions as to how they can resolve their dispute, or at least settle some of the issues that are in dispute between them. As you know, the function of a conciliator, like a mediator, is to give each party a reasonable opportunity to explain their side of the dispute. However, unlike a mediator, a conciliator will also make suggestions to the parties about how they might be able to resolve their dispute. Importantly, though, it is up to the parties to see whether they can agree a resolution to their dispute. The conciliator cannot decide the dispute for them. As a result, for a conciliation to be successful, the parties must be willing to compromise with each other. Besides making suggestions about how the parties might be able to resolve their dispute, the VCAT member in a compulsory conference might give the parties a view of what the decision is likely to be if the parties cannot reach an agreement between themselves and instead the dispute is determined at a final hearing by VCAT. Any discussions or negotiations during the compulsory conference are confidential and must not be disclosed at a final hearing if the conciliation is unsuccessful. If a final hearing is necessary because the parties can't agree a resolution of their dispute at the compulsory conference, then a different VCAT member, that is, not the VCAT member who acted as the conciliator, will decide the dispute at the final hearing. Look down the left-hand side of your vocabulary sheets, find the term compulsory conference and write a description of that term in there. The third dispute resolution method that VCAT uses to resolve civil disputes is a final hearing. You should already have included a definition of this term in your vocabulary sheets. A final hearing is a method of dispute resolution for civil disputes where the third party who conducts the hearing, in this case a VCAT member, listens to both sides of the dispute and makes a decision that is binding on the parties. Now remember, even though we refer to this dispute resolution method as a final hearing, it is still possible for a party who is dissatisfied with the decision made at the VCAT hearing to have the decision reviewed by appealing it to a court. I'll come back to this in a minute. Nonetheless, we refer to the VCAT hearing as a final hearing because the decision made at that hearing is binding on the parties unless it is subsequently reversed on appeal. Where VCAT uses a final hearing as a dispute resolution method, a VCAT member hears the dispute. Both parties argue their case and present their evidence, including by calling witnesses, and the VCAT member then makes a decision that resolves the dispute for the parties. This decision is binding on the parties in the sense that the parties must comply with the decision. As part of resolving the dispute, the VCAT member can make a range of orders. For example, the VCAT member might order one party to pay the other party money, as where the VCAT member decides that a supplier must refund the purchase price for defective goods to a consumer. Alternatively, the VCAT member might order a party to do something or not to do something. For instance, in a dispute between a landlord and a tenant over the state of repair of a house that the tenant rents from the landlord, the VCAT member might order the landlord to repair the house by, say, fixing up the drains or fixing up a hole in the roof. Or, in a dispute between a developer and a local council over whether the developer can build a large apartment block, the VCAT member might order the developer not to build the large apartment block. The VCAT member can even change or cancel a contract between the parties. For example, in a dispute between a car trader and a customer who's bought the car, where the car trader has sold the customer a defective car, but the contract for sale states that the car trader gives no guarantee about the car, then VCAT might change the contract to include a guarantee under which the car trader must fix up any defects in the car during the first 12 months after the sale of the car. It's important to remember that VCAT's decision at a final hearing is binding on the parties in the sense that they must each comply with it. If a party does not obey an order that is made by VCAT, then the other party can file that order with a court. In such a case, the order can be enforced like a court order. This means that if the party that's refusing to comply with the order continues to refuse to comply with that order, then they will be in contempt of court, and contempt of court is punishable by a fine or imprisonment. A VCAT final hearing, like a court final hearing, is open to the public. However, VCAT is not a court, and so the doctrine of precedent does not apply to VCAT in the sense that VCAT is not bound by its previous decisions. As I've said, the fact that we describe this dispute resolution method as a final hearing does not mean that a party who's dissatisfied with VCAT's decision can't appeal the decision to a court. On the contrary, if a party is dissatisfied with a VCAT decision, then they can have that decision reviewed by the Supreme Court. Where the VCAT decision is made by the VCAT president or a VCAT vice president, then the decision can be appealed to the Court of Appeal. This is because the VCAT president and vice presidents are judges, and so it's appropriate that their decisions should be reviewed by the 3 Supreme Court judges who make up the Court of Appeal. However, where the VCAT decision is made by another VCAT member, that is, it's not made by the VCAT president or a VCAT vice president, then the decision can be appealed to the trial division, where it will be reviewed by just 1 Supreme Court judge. An important restriction, though, is that the only ground on which a party can appeal a VCAT decision to the Supreme Court is that VCAT has made an error of law. That is, on the ground that the VCAT member has misapplied the law. A party can't appeal against a VCAT decision on a question of fact, that is, on the basis that the VCAT member has come to a view of the facts or the evidence that the party disagrees with. Well, that brings us to the end of this video. As a result of watching and taking notes on this video, you will have the background information that you need to be able to describe the purposes of VCAT in resolving civil disputes and to discuss the appropriateness of VCAT in resolving civil disputes. This will be the focus of our next video. Thank you for your attention.